Okay, hang on, let's see. Waiting for the host. System connecting. Welcome, we'll let you in just.
Okay, so we're good.
Yeah.
Okay, so hit continue.
See, waiting.
Oh, but I want this to stop recording though for right now. How do you stop recording? Oh, pause or stop.
All right. Basically, this is going to kind of be analogous to your special exceptions and that sort of thing. That's covered here in 502.7. So pleading amendments can happen up to 7 days before trial, and actually you can amend less if you can show that there's not going to be any surprise. And again, you got judges that have different life experience. They might just let you get it in there. Who knows? Or you say like, I've got this case tomorrow. It just gets dropped on your lap. The client's like, hey, can you come to court with me tomorrow? Okay. And surprisingly often that actually happens to me in justice court. So I definitely had situations where the judge is understanding. Usually they won't let you go too crazy, and they might grant a continuance, but they'll let you amend a lot of times. And then 502.7 permits for insufficient pleading. Again, this is the special exception kind of rule. So sometimes the things that you see pro se people will write, sometimes it'll just be, I was harmed. And sometimes they'll write essays that are just incoherent mashes of words that are connected by no connectors, no punctuation, and you're just trying to figure out, what is this even saying? So this is the rule that helps you to deal with that. And you can get to have a hearing on it, and then the judge can order them to replead. If they fail to do it, eventually they can dismiss the case. So all of those are available on the table. All right, motion for summary disposition. Because again, Justice Court, we can't use normal terms that you're all familiar with from the other branches of the public courts. This is just a motion for summary judgment by another name, except it's a little looser. So you'll see it's covered by 503.2, and the party can, but doesn't have to, file a sworn response. And then at the hearing, the judge may consider evidence, which means that the pro se can basically just show up and start just talking through it. And there's a decent chance that your motion gets shot down. Now, it kind of depends, and this is where a lot of this, this is the same kind of advice that you all have about any other kind of court, but knowing your judge is just incredibly important and incredibly helpful. And so to the extent any of you get stuck in front of Justice Court, feel free to reach out, and I have opinions that I can share with you in a non-recorded environment about the various judges that you might find around here. A lot of times, particularly the judges that aren't lawyers, will give pro se's a lot of leeway on this, and we'll let them go ahead and bring in evidence. So you want to be prepared for that. All right. Fun question. See how well y'all are paying attention, if you have a feel for how justice court is. Do the other rules of evidence and procedure apply in justice court? What do we think?
No. Yes,
You're not as wrong as you'd think, but generally, no, unless they do. So 503.E provides that the rules of evidence and procedure apply when the judge determines that the rule must be followed to ensure a fair trial. Boy, that's a nice, solid black letter standard for you, isn't it? I clearly know when the rules are going to be applied and not applied now, don't I? Yes, and I get that in writing before they go. No, you don't get that in writing before you go to trial. You could just show up that day and the judge is like, I'm going to apply the hearsay rule today for fun. Or I'm going to apply, sure, anything, any of the rules. And basically it's just this to ensure the proceedings are fair. And, fair is very much in the eye of the beholder. So. And then also there's another carve out in there, when otherwise specifically provided by law or these rules. See? It's so clear.
Lawyers wrote this, right?
Right. Not top tier, like we weren't paid top dollar. Basically, judges can decide when they do and don't want to use them. And in practice, I do find that most judges still will take a hearsay objection. But most of the other rules, a lot of times they'll just say like, well, I'm going to let it in. It's even more fun. So I just had a trial yesterday in JP court, but with a visiting judge. He was actually a judge that had previously was a county and district court judge. And honestly, he's an older gentleman. He's retired. He was struggling, and we were doing this via Zoom. So he was struggling with the technology. And then, I'm making clear hearsay objections with this other party, talking all about statements other people made. And finally, it got to the point where I was like, Your Honor, he's just overruling them. It was like, can I just make a running hearsay objection here? And he's like, yeah, I know what evidence needs to come in or out on this. I'll take that. Great, thanks. So
Did you win?
I did. It was even if it was basically, it was kind of like, nobody got anything. It was a dispute over security deposit. We were counting claiming it was like this was peanuts. This was $86 was what she owed. She was suing for $7,200 for, she claimed that, that she was constantly being propositioned by her neighbor for sex, that some kids next door had scratched FU into her car, but she wasn't suing for the car damages. So it wasn't clear why that was relevant, but she kept bringing it up. She also was suing because there were some lights that had gone out. She had to park in a different parking spot, and she wanted her old spot back, but they weren't assigned spots, so I didn't understand why that was relevant. So she did get her $100 deposit back because the judge didn't understand the prorating of utilities. And but then we got our attorney's fees, so now she owes them $2,500, which gives you an idea that justice court, not terribly expensive. So got that going for you. All right. So none of the rules of evidence apply. No, yes. One does. So 500.7 specifically provides that either the parties or the judge can invoke the rule, basically the exclusion of witnesses, that are not parties and that aren't testifying at the time, just to keep them from mimicking the other stuff. And in practice, I will tell you, most of the JPs here in Travis County do automatically invoke that. That one just gets brought up all the time. So to the extent that there is any rules of evidence of procedure that you can rely on when you go into justice court, that's probably the one. So I can't issue a subpoena, huh? Yes. No. Rule 500.8 is the justice court subpoena rule, and it's functionally the same as the one you're used to doing. Lawyers can issue them, or you can have the clerk if you're, acting in a pro se capacity. Because again, you sued, I don't know, your lawyer because he was being a jerk to you that day. He was so mean, right? Can I serve discovery in justice court? What do we think?
Yes.
Nice. I like I'm getting some doubt from you. This is so confusing.
You think that you could, but
I know. Yes. See, my presentation's working for at least one. No, unless you can. Rule 500.9A provides that you must get permission from the court to serve discovery the judge considers reasonable and necessary. Now imagine going and arguing for what is reasonable and necessary discovery in front of a judge that never went to law school, that's never filed a lawsuit, never handled the case. You get to do that. You do have to file a written motion, and you have to attach the proposed discovery along with it. And then that goes to the judge. And then only once it's authorized can you go ahead and serve it on the other party. But the judge can authorize it. Post-judgment discovery is permitted, as long as you do 30 days without having to get that extra permission. So
how does that go with the eviction things that take place within 10 to 21 days?
No, that's an excellent question. So what happens is when I'm handling a case and someone like legal aid gets involved, they'll serve a motion for expedited discovery. And I will tell you that all of the judges here in Travis County will basically grant that. And so usually what you'll end up happening is you've got to turn that a discovery over within, it's usually like 5 days, or it'll be like 2 or 3 days before the trial. So that absolutely happens. But yeah, no, discovery does occasionally get brought up in eviction cases.
Are the other justice cases on a similarly faster track than what you might find in county court?
Yeah, they're still faster, and that is a great question. So with the difference, one of the differences, obviously, you guys know that you always have to set your own trials in the counties and the district courts. Justice court will go ahead and set that trial for you. If typically they'll do a courtesy if you're a lawyer, and they'll reach out to you to coordinate that. But as far as if you're just straight up pro se, they'll just set it and send notice. And yes.
I have a question. As far as like the DWAP dockets, how lenient are they? Because if they have an affected service, we have a case where they filed a motion to retain and they still done nothing, and it's been going on a year.
Yeah, they're pretty lenient on the DWAPs. They do happen. I would say for whatever reason, precinct 5 is a little more.
Sylvia.
Oh yeah, Judge Holmes. No, she's not very aggressive with her DWAS.
Okay.
So I wouldn't worry a ton about it. But yeah, basically, so you haven't been able to get service on the defendant, or I see. Yeah, well, and I mean, there are procedures for filing for substituted service or service by publication in the rules.
Yeah.
So
Yeah.
might consider looking at that. And then plus, I will say, I think Judge Holmes is also very sensitive to the relaxation of everything that's happening right now. And then the recent extension, I'm sure we're all familiar with the Texas Supreme Court's order relaxing deadlines and everything running through October 1. But I know Judge Holmes has been pretty accepting of that stuff. So, but back to faster track. Yes. So no, you're actually. I'll step on my own thing. Actually, is it the next one? Yeah, there it is. Hey, trials. Informal. TRC PD 500.6 allows judges to ask questions and develop the case. I do find that happens, particularly with the pro se people. The case, that trial I was telling you about, I just had yesterday. I had the judge, and he was asking the tenant, like, basically, she sort of gotten to the end of her ranting about what she was so upset about. He's like, all right, well, now tell me how you calculated your $7,200 in damages. And she didn't really get there, so that's part of why she didn't really get into the damages. But the judge, this is wacky, the judge can subpoena a witness if they think they're necessary to the case. I've been practicing, I think it's 13 years now, yes. And I've had that happen once. So it's not very common, but I did have it happen once. I could not believe the judge was like, you know what, Mr. Rogers, we're going to continue this case, and I'm going to subpoena so-and-so and bring them in here in court for in a week. I was like, really? Yeah, she did. Still won the case, so that was okay. But most often, I will tell you, judges, particularly, and this is more the actual JPs that are here, they'll go ahead and push and try to keep things to an hour, especially if it's not overly complicated. You don't have a lot of witnesses. I mean, jury cases obviously are a little different. But I'll tell you, visiting judges, and again, this is that judge yesterday, they tend to allow things to run long. That was a 2.5 hour trial yesterday that basically left all of us dumber for having experienced it. I didn't include it on here. Trial notice, I'm surprised I didn't put it on here. Got to be 45 days. So basically, you will get your notice of trial at least 45 days out. And if for whatever reason a JP messes that up, and they sometimes do, you can file a motion or send them a letter. Honestly, if you send them an email or a letter, honestly, yeah, you can even just call, and they'll say, "Oh yeah, sorry about that. We'll give you the full notice." But yeah, I guess dockets do tend to run faster. Obviously, COVID's thrown everything kind of up in the air. I would say that in most normal times, from filing to suit, on the shorter end, you might have your trial, you might be done in 90 days. On the longer end, I've had cases in busier precincts where it's kind of low priority because again, they got to run through those eviction cases, the eviction cases. But like
number 5 always takes a little.
5 and 5 is one of the busier dockets. Just again because of the nature of the number of businesses and everything that are all located there. But on that longer end, I've had cases that sat for a year and a half before I got a trial notice. So those happen. But it's typically closer to that shorter end. All right, jury trials. You do get to have juries governed by Rule 504, conducted in front of a petit jury. I prefer petit fours, but petit juries are good too. Yeah, all right, I got some chuckles there. You can request it at least 14 days before trial. You got to pay your $22 jury fee. You do get voir dire. You do get 3 peremptory challenges, which I think I always say preemptory, but I didn't realize that I was saying it wrong until I was making this slide last night. I was like, oh, it is peremptory. Who knew? Not an English major. You do get unlimited challenges for cause. And then one thing that's quirky is evictions, again, because that's a short timeline. You can request jury trial up to 3 days before that trial. But again, sometimes you're only getting, a week or less. So that's what happens. You are not, they're very explicit about this, no jury charge, which is really funny because I know, a lot of y'all, especially I'm sure that handle like PI cases, like basically you build your entire case around you. You start like, all right, here's my charge. Now I'm going to build my case around this, and this is how I'm going to draft my pleadings, and this is going to how I'm going to do my discovery. That's all out the window in JP. Don't do that. Which again can lead to some really wacky stuff with juries. I I did have a case a few years back with a jury trial. This is actually, this was more than a few years back. This was the last time that Precinct 2 had a non-lawyer JP. And I was doing this eviction case. This guy had like threatened a bunch of the lawn maintenance people that were out there working, and then had done some other weird stuff, had like done weird wiring modifications to his apartment, and had put up a bunch of cameras. And I mean, all of these things were clearly prohibited by the lease. And basically, he was just like, he probably wasn't actually a schizophrenic, but he felt like a paranoid schizophrenic. And so he comes into court, he's got all his evidence, these documents all over the place, and he's got this one big trash bag. And the whole time, the jury were all waiting, like, what's in that bag? What is that? It's a big white trash bag. It probably feels like it was this big. I'm probably like doubling it in size, but it's good for the story. And so finally, I finished my case, and he's getting to go. And so then, he's going through his case, and Your Honor, we got the jury all sitting there in the courtroom, and he's like, and Your Honor, I have the proof that they broke my windows. And he picks it up and he throws it down, and it's this giant bag of broken glass. And you're just like, and the judge just stops and it's like, bailiff, could we escort the jury out at this time, please? So the bailiff takes the jury out, but then I'd like you to return. So the bailiff escorts the jury out, comes back in. Bailiff, why did you allow that man to bring in a giant bag of glass? And the bailiff sort of like, I never got a good explanation of it. I didn't set up a metal detector. It's true. I mean, he walked through. I don't know. I didn't see when he was going through, but it was wild. Yeah. Still good on questions?
We're good so far, yeah.
All right. Motions to reinstate, set aside defaults, or for new trials. You have options for all of them. These are governed by new slides. This is governed by Rule 505.3. So on a motion, to reinstate after that DWAP you get 14 days to file it after dismissal. For the defendant, they can file with 14 days after the judgment, and both are decided based upon good cause shown. Very loose standard. In practice, honestly, I find most JPs, if they get a timely one of these, they grant it. Honestly, I'm not sure I've ever seen a JP that didn't grant one for it. Motions for new trial have to be filed within 14 days, different standard, showing that justice was not done. After all of the stories and everything you've heard about Justice Court here today, you might think that that's every trial. But that's your deadline. You're limited to one new trial per party, and then it's denied as a matter of law 21 days after judgment. And that denial as a matter of law, 21 days after judgment, is incredibly important because that's also your deadline to appeal. So basically you're like, judge, on that 20th day, are we going to grant this motion or am I appealing? What's going on? You got to watch that. It's a real tricky thing, honestly. The lineup of that doesn't quite make sense. You would think that it would extend appellate deadlines like a normal motion for a new trial does, but nope. So governed by Rule 506, the appeal has to be filed within 21 days. In a case, a plaintiff has to pay a $500 bond, and the defendant has to pay 2 times the amount of the judgment. Seems a little unfair, but I didn't write the rules. But most practically what you see, particularly in evictions, but honestly in a lot of justice court cases, is when you have a pro se party, if they have any sense at all, or get any kind of a guidance from any kind of agency, they will file what is called a statement of inability to afford payment of court costs. And what that is basically, it's a statement, it's got some basic information on there. You give basic background about your income and your expenses, and then you say, I can't afford to pay the bond, and appeal this thing. And as a matter of law, you can challenge those, but again, how are you going to disprove it? You don't get discovery. And so most of the time, it's almost futile, unless you already happen to have like some incredibly compelling bank records or other knowledge that they're lying. And like, yes, they actually do live in that like $3.2 million estate down by Lake Travis. Unless you've got something like that that's got them dead to rights, these statements of inability get granted all the time, and then basically they don't have to pay any appeal bond, and then you just get brand new trial de novo with the county court. Evictions, slightly different. If you do the statement of inability in evictions, then they have to make an initial rent payment within 5 days. And this is specific to non-payment cases. If you conduct, you don't have to worry about this, but assuming that it was an eviction for non-payment, they have to pay 1 month's rent within 5 days of the date they file the appeal. Again, extended if it falls on a weekend or a holiday or a day that the court closes before 5:30. And then they have to pay that 1 month's rent. And then basically, as that case goes forward into the county court, each month as rent becomes due, they got to pay into the county court 1 month's rent. And if they don't, you can get a writ of possession issued immediately.
So that payment is made to the court.
Yes. So yeah, that payment, and then the subsequent payments get made should be paid to the county clerk. And basically, there's a specific procedure, it's Rule 510.9C, that allows you to file a motion. Well, with justice court, you just call the court and say, did they make the registry payment? No, I want my writ of possession, and they'll issue it. In the county court, you have to have a hearing on the issue, but otherwise, same. And then the trial de novo, your brand new trial, as if none of this ever happened, and this was all a terribly bad dream for you, can happen once you get up to the county court. I think that brings us to the end of things here. So,
I
happy
have
to
a
take.
question, you don't have
Yep.
to answer it.
Oh boy.
If you had a case that somehow could be filed in any of our Travis County precincts, where would you file it? Because then I'll go the other side, because you're on the bad side.
If you have a sad sack, good emotional case,
Mm,
I would say I would file it probably in precinct 1.
okay.
If you had a case that's based on just straight clear-cut contract or law, I'm probably filing that in 2 or 5. But I really shouldn't shortchange 3 or 4. They're both very fair. 3 and 4 are very fair. I wouldn't say there's a leaning one way or the other.
Judge Williams was a legal writing professor at ACC when I took the paralegal program. And
Yep.
she was also like an overnight magistrate judge, and she would tell us, hey, just get to class. If I'm not here in 10 minutes, y'all go home. And then we had a few like cases in her court, and it was kind of the same. She came in when she felt like it and let people cry, yell at their family,
I mean, she's the one talking about Judge Williams in this way. I am not saying these words.
She's fun, but yeah, she is. That's the one you said, emotional. So yeah, we've had some probate cases, because we do probate, where we've had to evict family members who don't want to move out of grandma's house that they don't own, and it's just like Jerry Springer.
And I mean, and honestly, the Jerry Springer part, that's not actually unique or special to Judge Williams Court. You will see that that case I was telling you about, the giant bag of glass, that happened in precinct 2. So wacky things happen in all of these courts.
Yeah.
Fun fact, precinct 1 judge was my kid's soccer coach.
Oh, really? Oh, she's super sweet. She's really nice. I like Judge Williams a lot.
Yeah, I did too. I didn't have to do much work in her class because she didn't show up.
I'm sorry, it's 3.
3?
Yeah, Arturo.
Oh, that's precinct 4. Yeah, Judge Gonzalez. Oh yeah, I like Judge Gonzalez a lot.
Yeah.
His daughter and my daughter are about the same age. He's really nice. He's a very fair judge. I sometimes will disagree with what he does, but I think he does a very good job of the King Solomon splitting the baby stuff. Boy, that's hard.
Do your justice cases ever go to mediation?
So,
This is just like an expense that costs more than the whole.
and honestly, that can happen. I have had a few. It's been a couple of years. Judge Evans, funny enough, we mentioned him earlier. Judge Evans in precinct 5 used to pretty regularly refer things to mediation, but most of the JPs don't. It is an option, basically in any case except for the evictions and the repair and remedy cases. In fact, there's a specific rule that says, like, there's a rule for having pretrial conferences that we had talked about. I mean, it's just, you have pretrial conferences, like any other pretrial conference. You talk about the trial date, you talk about the issues, you talk about whether you're going to do discovery. But as a part of that, you can't delay the trial specifically for an eviction. And so you just don't see a lot of mediations in there. Now, arguably right now, with the relaxation of the rules provided by the emergency order of the Supreme Court, they probably could, but they haven't been doing that. I do have a case actually from a Dallas JP appeal that went to county, and there they routed me straight to mediation. So I'm having to mediate it before.
Any other questions? Comments, tackles?
No, I have a question.
Sure.
If you were not able to
was started with it depends. Could you tell us which JP court is your favorite?
Record.
Yeah, you're like recording. We're going to stream this to the judges all have YouTube pages right now, so all the courts do. Oh, I have a pretty good relationship with Judge Holmes. Judge Holmes might be my favorite. She's precinct 3. She is newer. Yeah, I think she's only been reelected once. Her previous judge there was Judge Steve, who was on the record on the bench for probably a long time. But yeah, but I mean they're all good. Like so, I guess. All right, so yeah, we might as well talk about it. So, all right, Judge 2, precinct 5. His background: he was an assistant district attorney, and that's the background he came in. He came in 2016. Judge Evans, he came in. He resigned or stepped down midterm. I don't remember exactly what the reason for. I guess he was just desperate to get to Hawaii, as I mentioned earlier. But then Judge 2 was appointed, and then he's been reelected once. Judge 2, he's very influential. He is there's a task force that's been dealing with a lot of like landlord-tenant related issues and in connection with the Texas Supreme Court, and especially during the pandemic and earlier on. I don't know if y'all remember, there were some specific orders that came out that stopped and prohibited evictions, and he was on the task force. In dealing with those situations and talking about that. So honestly, I think he's kind of an up and comer. I could see him district county court one day. Actually, funny, now that I mentioned that, believe it or not, there are 2 current Third Court of Appeals judges that started as JPs here in Travis County. Judge Triana and Judge Goodwin. They were both, I think Goodwin was precinct 3 JP way back in the day. I don't remember where Judge Triana had been JP. But then they became district court judges, and then now they're both on the Court of Appeals. Let's see, so that's Judge 2. Judge Gonzalez, precinct 4, he's been on the bench for, it's probably 15-ish years. And he was with the Attorney General's office before that. But I don't think he has, honestly, I don't feel like either one of them bring too much of a prosecutor's mentality to things. I think that they look a lot to fairness and equity. Judge Slagle, he was another former assistant district attorney, and he's precinct 2 judge, and he's a pretty fair guy. He actually, it was funny, I had a case with him once. Just silence your phone. So I know that he actually has rented out property in the past, and so it's interesting. He'll have kind of he'll have opinions on like landlord stuff, or that you might not go with.
Personal.
Yeah, I mean, not like it's not like he's like trying to case that he's personally involved in, but like he has perhaps more experience with the trials and tribulations of dealing with landlord and tenant issues than some of the other JPs. Judge Williams comes from very much a legal aid background, poverty law, public policy kind of background out. She was like a briefing attorney for some very prominent for Court of Criminal Appeals. That's it. Okay. And so she has that interest. She actually does a lot of, I know we were mentioning magistrate stuff. She'll do a lot of stuff for criminals. This shows my lack of knowledge about criminal law, but when the criminal needs to bond out or whatever, she'll sign. She handles a lot of those. Somewhat controversially, you can Google the articles to read about it. But I like her a lot. As Amber mentioned, she has a penchant for not always getting places exactly the time schedule. But I still appreciate her. She's a good time.
Do you work for like people who rent out their Airbnb? Is that a thing, or?
What do you mean, like?
Well, I'm just wondering, the last time we stayed at Airbnb, the host allowed pets and then suddenly changed and said if I wanted to bring my pet, then I could pay her an additional kind of, deposit. But I'm like, no.
Yeah.
So, and I don't know if when they sustain damages to their houses, they just go for Airbnb.
I mean, that screams DTPA at me. Yeah, I mean, you certainly would have a potential cause of action for like misrepresentation, breach of contract, depending on like, you know, if that was terms were spelled out before. Pets are obviously a big issue that comes up in landlord tenant law, and see that in justice court.
Does anybody else have any other questions? All right, well, let's, okay, just a few more minutes and we'll do the door prizes and everything as well. As a speaker gift, we're actually changing things up this year. We usually give people like a fancy CAPA coffee mug or something. In lieu of that, we are actually going to start doing donations to charities in our speakers' names. And Corey has chosen Carrying Hope, which is a foundation. They distribute hope packs with like necessities, toys, and other items for foster children. So we're excited to be able to contribute for that in Corey's name.
Thank you so much.
Thank you. Appreciate that. That was a great presentation. All right, just a few quick announcements. Upcoming events, we have the Meet the Board and Sustaining Member Vendor Parade. That's on August 4th, which is at Vesper, which it's somewhere downtown. I don't know, but the address has been published. We can get that for you guys. There is parking. If anybody else is super weird about parking, there is parking. Because I don't go somewhere unless I have parking mapped out if it's downtown. So we're good there. East Austin. Okay. Well, there too with the parking situation. You never know. Okay, and then the next few months, I just wanted to give you guys like a brief outline. Next month, we have Emily Morris with the Morris Law Firm. She's going to be speaking on business, IP, and entertainment law. In September, we have Lisa Harding lined up to speak about a topic related to criminal law. We don't know exactly what that is yet, but that'll be fun. I don't think we've had a criminal law speaker in a while, so that should be interesting. In October, Lori Ratliff will speak about appellate law, and in November, we have Neil Falgust from the city of Austin. So those are the next couple months with the speakers. And with the Spotlight Committee, we have social and networking. So if Brittany and/or Lindsay want to come up and say a few words.
Okay, I'll make this short and to the point. So as she said, we have the Meet the Board on August 4th between 5:30 and 7:30 at Vesper. This is an indoor event and drinks and apps will be provided. Don't forget to bring your gently used books for the Inside Books project. If you can't bring them that night, you can coordinate with me and we'll get it to them. Let's see. Paralegal Day, October 20th this year. We don't have the details yet, but that will be released soon.
You know about Paralegal Day, right? It's an actual day where you have to do something. I can send you a reminder if you didn't know.
Hey, will you put that on my calendar?
And then last
get yourself a
we have CAPA's holiday party on December 16th at the Booker's house. So those are just some save dates for you guys.
Yay, thank you.
Okay, so our spotlight vendor today is Molly Galvez with TBLS. Do you want to come up and say a few words?
TBLS. Who's TBLS here? Yeah, go for it. If you want the mic, I can turn it on.
No, that's okay. Some of y'all know I am Molly with TBLS. We are a small staff of 6. That includes our director. The rest of us handle attorney files, and I'm the only one in the office that handles attorney and paralegal files. So out of our 350 or so certified paralegals, I'm the main contact. You will have any questions about applying to become certified, I'm the one that you email, phone call, reach out to me, and I'll be your main contact. You start an application, I will be with you from start to finish. Once you become certified, you will not get rid of me unless I do. I have been with TBLS. This is going to be my 18th year with TBLS. So I've got to enjoy a lot of luncheons with you guys, other organizations. Also been to attorney lunches and things like that, advanced programs for the attorneys. So one of you knows me, my name will probably pop up somewhere when certification comes up. We have 2 separate websites. One website is strictly for attorneys. Sorry. And the other website is for you guys. It's not as interactive as I would like it to be, but all of our information is there. That website is tbls-bcp, Texas Board of Legal Specialization, Board Certified Paralegal. If you just go online, Google search board certification, TBLS, hopefully we pop up. We have our applications are open at the time. We have an August 15th deadline. Unfortunately, the paper and the fee have to be mailed in. So your fee is by check or money order. The application is fairly small. We pretty much just want to know what you do on a daily basis, how often you do it. The attorney that you work for or supervises you is the attorney that signs off on your application, confirming that you do everything that's on that application. We do have quite a few freelance paralegals or contract paralegals, and for those types of positions or that type of work, we ask that you get the attorney that you spend most of your time with sign off on that for you. There is a CLE requirement, 30 hours of CLE. 30 hours, it's 10 hours of self-study, no explanation needed. You just tell us I want those hours. The rest of the hours are participatory CLE. It could be CLE lunches like this. It could be programs that other local organizations put on, in-house CLE. And for us only, I'm not sure how other organizations will accept your CLE, but if your attorney, a group of attorneys in your firm attends advanced programs and they bring back that material, borrow it, do it on your own time. Once you finish, I'll need an affidavit from that attorney that says, yes, paralegal so-and-so borrowed this material from me and she did it on her own. He did it on her own. I will take that as your hours. Do y'all have any questions?
We have an estate planning paralegal, because there's not very many TBLS estate planning paralegals, who there was one qualification that she didn't exactly match, and I told her to talk to you.
Oh, no. If you ever have any questions or doubts about if you qualify or not, call us. Call me.
Call your
email me. Any way you can reach me. If you're scared and you know somebody else, just have them ask. We work with everyone, individual basis, everything is looked at. Please, just call. You just don't know.
And we have some TBLS study groups going on here, or if you're TBLS certified and you want to help other people, let us know. And just so you know, Molly approved your presentation, Corey, for civil trial law, family law, and personal injury trial law. So.
Okay, Mom.
Yeah.
I mean, it was pretty great.
Yeah.
Well, thank you, Molly. And she brought a door prize. Do you want to draw a card? Sorry, we give prizes, but not to lawyers. Let her draw a card. Your lunch is by the door.
Now I know what it's like to be that second-class citizen in the office.
Yeah.
This is Rocio Lewis.
Oh. Like wine. That is paralegals like alcohol gifts.
Yeah, any questions? My information is on our website. Like I said, find us tbls.org.
And on our website.
Oh, and their website too. Links.
Yeah,
Links go to us.
Yeah.
But any questions, any hesitation, feel free to call us.
She's not as bad as they
No. I promise.
Thank you, Molly. Thank you. All right, a couple more prizes. During my term, I had a little extra money in my budget, so I got us some Zoom.
I'm sorry, right, yeah.
We got some golf umbrellas. This is big enough for you and your lawyer.
You don't care about them.
This is going to Elizabeth Morgan. Also a walking stick.
Nice.
Thank you. Welcome.
All right. Post your lawyer for B&B.
Yeah. Or to pretend you're gonna hold it for me. This is from Lexitas. It's a $30 DSW gift card. Celeste. All right, then we have Amanda from TLC is here. Where's she at?
And they always have really cool baskets too. Crystal Rosa. You're welcome. And then we are offering a gift card that I'll send you virtually from Reward Unit, so you can pick your own place to use it. And guests can register for gifts too, or anybody who's not a member. I think most of you are members. All right, Lindsay Ford. Your gift card. Thanks. Anything else? All right. Going. More prizes. All right, just a few more sentences and we'll get out of here. Okay, thank you guys for joining us. We really appreciate it. Thanks for being patient with the hybrid stuff as we get that figured out. And again, please send us any feedback or constructive criticism. Do not send us anything mean. We don't like that. But you can email us. It's board, BOARD, @capatx.org. Please make sure to leave your CLE surveys on the table. You can also donate to the flower pot funds. Just throw some quarters, change, dollars, whatever you have in the flower pots. We'd greatly appreciate it. That goes directly to mobile loaves and fishes. And also make sure that you grab your CLE certificate by the door on the way out. And that's it. Thank you all for being here. Meeting is adjourned. Thank you.
Stop the recording.